Here we are at the fun stuff. It's called Bankruptcy, Chapter 15. And we're also going to look at creditor rights. So this is the tail end of this week. Should be in two parts. This part will be the framework, and then we will discuss bankruptcies down here and do a comparison. So let's start with terminology. It sounds rather odd, but this is very legalese, so just bear with it. There's something called an artisan's lien, which is when somebody doesn't pay for something, the person that is not being paid can take control of that piece of property. There are two of them. One is called an artisan's lien, and this is a possessory lien, which means an example I think they gave in the book was somebody wanted their diamond ring worked on. They took it into their jeweler, and then they couldn't pay for it. So the jeweler put an artisan lien upon the ring and kept possession of the ring until the amount was paid. One of the things that has to occur with an artisan's lien is the whole transaction needs to be for cash only. There can be no credit implied with it. Next one's called the mechanic's lien, and that's a lien for real property. Let's say somebody put siding on your house and you refuse to pay for the siding. They could file a mechanic's lien on the house so that one, they can use it for collateral until you pay that bill, or when you sell the house, then that would have to come out of the proceeds first. There's surety, and a surety here and guarantor kind of go together. These are third parties, typically, or somebody outside of the initial creditor-debtor, that are involved in the transaction. Surety is a person who, though not getting the loan, is going to be primarily responsible for it. It could be maybe a student loan from a bank, and they're getting the parents are getting a loan for their child. The child is signing for it because they are of age, but the parents have said, we are going to make the payments on the loan. That's a surety. On the other side of it is a guarantor, who would do the same thing, only would say, okay, if they don't make the payments on it, I will. So a little bit of difference there. Discharge. And discharge is when somebody who's filed bankruptcy and it's finally complete and all of their debts have been finalized, removed, no longer part of their responsibility. That is called discharged. Garnishment is when somebody doesn't pay a bill and their wages become garnished or appropriated to pay for that bill. That can happen, I think typically is what I see most often with that is child support, or any type of a divorce settlement of such. You've got a homestead exemption, which is when you file for bankruptcy, usually you get to keep your house, or your home where you live, and some personal property, and this is called the homestead exemption. Now each state is different on how much or what is the limit that you can keep. Then there's estate in property, and that's basically everything you have that will be put into the bankruptcy. Perfection is used and talked about down here in secured transaction. When they're perfecting a security, that means filing a legal document that says a third party cannot come into this exchange and take control of whatever collateral may be being presented for the transaction. Writ of a attachment and writ of execution you'll find down in liens. And a writ of attachment talks about a court order to seize property before there's been a judgment, a final judgment. And a writ of execution is when the court orders the sheriff to seize property and sell it. You've heard of a sheriff's sale. That's actually a writ of execution. And then debtor in possession means that even though they're in bankruptcy, they are still in control of the property and maintaining and continuing the operation of the property. So that's the terminology. It really wasn't that bad, was it? So we have laws that assist creditors, and those laws are in place to protect creditors. Otherwise, if they didn't have protection, there would be no money being lent back and forth. There would be a cash-only economy, and sometimes things can't grow in that situation. So we have laws that assist creditors or protect them. And the first one is called the secured transactions. And usually, when you take out a loan or somebody has a loan or borrows money, you have to put up collateral. You will have to sign a security agreement. Whoever you're signing the agreement with is going to give value, such as you go to the bank to buy a house. Your collateral is the house. The value the bank gives you is the money to buy that house. And if you're going to use that house for collateral, it has to be yours to use as collateral. Once this has been established, then this will be filed. It becomes a financing statement, and everybody has signed these, and they've been filed. Then it comes to the priorities of, let's say you have two creditors that you've signed a financing statement with for that house. The first one is for when you bought the house, and that was for a certain amount of equity, or a certain amount of money for that house. If it's a $120,000 house and you borrowed $60,000, you owe $60,000 on it. You've got $60,000 in equity. So then you go out and you say, well, I really need to do some improvements on the house. I'm going to go out and get a second mortgage from another bank. So now you have two creditors vying for the collateral of that bank. So they have to set some priorities. So your first creditor would have first priority. The second one would come in at the second priority if you had to file bankruptcy. And the remedies, you can have a secured party can repossess or foreclose on a house or repossess a car or come get your television or whatever it is. Or you can have a judicial judgment against the party who borrowed. You can also do liens and other means of protection, which we'll talk about here in a second. But right now we need to do a question. So I'll leave you to the question, and I'm going to move on, and we'll be waiting for you in liens. So I hope the question wasn't too bad. A lien. There are two types, and we kind of talked about that up here when I was doing the terminology. There's a mechanic's lien, which is on real estate and anything connected with the land. And then there's an artisan's lien, which is personal property. And remember, I said the artisan's lien was possessory, which means the person who files the lien has possession of the personal property and will continue to have possession until the bill is paid. And then you have a judicial lien, and that brought up the writ of attachment and the writ of execution. So you've got three types of liens, and then there are other ways of protection here. Wages can be garnished, and you can have what they call a creditor's composition agreement, and that's where you will sit down and the creditor and the debtor and work out a deal without going into court to settle for less money typically, or maybe to extend the payment period. And there's third-party satisfaction, where if you have a co-signer or somebody who says, I will take care of that bill if the original debtor does not. And that's a really a very good protection. And gosh, it looks like we're ready for another question. So those are the protections for your creditors. And I will see you when we get down to protection for debtors. So protection for debtors, of course, bankruptcy is one option, obviously, and we're going to be going into that in more depth. But there's the homestead exemption, which protects the real estate, the home, and some personal property also. Then bankruptcy itself can be a protection from large amounts of debt. It can get a debtor out from under and give them a new start. So bankruptcy proceedings, I'm actually only going to talk about the two laws that have kind of stirred up the pot a bit. The first law is the Bankruptcy Reform Act of 1978. And when this came out, it made rules for debtors much easier than what it had been before. And there was an explosion of sorts of bankruptcies throughout the later 70s, all of the 80s, and into the 90s. It was very easy to file bankruptcy. It was very easy to get out from under, many times keeping most of your possessions. So credit card companies and people who were making loans were getting a little bit nervous, especially credit card companies, because they're an unsecured loan. So along comes the Bankruptcy Reform Act of 2005, which made it much more difficult to file for any type of bankruptcy. There were more repayment options instead of liquidating. You could repay in many different ways. There was limits placed on the homestead exemption about how long you've owned the house, how much it was worth, how long you've lived in the house. Bankruptcy filing any of them has become much more time-consuming and costly. So things just became a little more difficult, and bankruptcies obviously have come down. And the other thing is, I believe you have to do debt counseling 6 months prior to filing bankruptcy now. So there's been a lot of stipulations. There's a few hurdles put in front to slow people down, to make them think twice before they file bankruptcy. And we have another question, and I'll let you go do that, and then I will do a very short overview of what we've talked about, and we'll be done with this part of the lecture. So what you need to remember is we have some brand new terminology. Isn't very hard. We have laws that protect the creditors, secured transactions, liens, garnishments, and third-party satisfaction or guarantee. And then we have the protection for debtors. And we start with the bankruptcy proceedings then. Okay, thank you. We are off to the actual bankruptcy.